4 family members in it, I don't get 4 program payment limitations for that egg operation. I only get 1 because the FSA rules say that the entity, no matter how many members there are, no matter what level of involvement they have in the egg operation, just because it's an LLC or a corporation, you only get 1 program payment limitation for that operation. Now contrast that if I had formed that entity as a general partnership. If I had mom and dad and son and daughter in this egg entity operation that formed as a general partnership, and each and every one of them were a material participant in the egg operation, what I've accomplished is I've got 4 program payment limitations. So before I'm disqualified or ineligible from receiving additional program payments from the FSA, I've got to exhaust the 4 program payment limitations that's given to me. So a very important consideration when it comes to choosing the operating entity for the livestock and the equipment that signs up for the farm programs at the FSA office. The other thing that we see out in the West that we have to keep our eye on the ball with is grazing permit rules. We have a lot of clients that are benefited in their operation by entering into grazing permits with the BLM, grazing district associations, the federal government in a variety of different ways. But as a result of the ability to enter into a grazing permit with the government or a grazing district association, we need to be mindful of what their eligibility rules are with regard to the tenant operating on that ground. And one of the things that we run into is the fundamental rule that everything needs to align with regard to that grazing permit. So the owner of the land must be the same entity or person that owns the brand, and that must be the same person or entity that's on the lease. So the tenant, the owner of the brand, and the owner of the base acres that qualify you for that grazing permit must all be aligned. And if you break that chain, you no longer qualify for that grazing permit. You could be at risk, in jeopardy, for losing that grazing permit. So a discussion that we'll have with our ranch clients that utilize grazing permits is, to what extent do you rely upon these base acres to qualify you for that grazing permit? And then we do the analysis of aligning everything up and not breaking that chain. So it's another element of planning that we bring to the table to identify the proper operating entity for our client who has grazing permits as an issue in their particular situation. One other thing that I wanted to raise, because we're just right on the heels of a historic blizzard atlas, is the fact that our livestock producers could be eligible for a disaster payment. Now, I get a lot of cowboys that come in and say, you know what, I don't rely on the government for FSA payments. I'm not a row crop farmer. So I'm not so concerned about qualifying for FSA payments. And therefore, we navigate down the path of talking about the pros and cons of an LLC or an E or some other structure to operate the livestock operation. And note, that's different than owning the land. We'll see some charts that we talk about later on about that. Well, now it comes to the surface that as a result of this historic blizzard and the historic losses that our livestock operators have, what we're hearing is that operators may be eligible for a $100,000 disaster payment. Disaster payments capped at $100,000 on your loss. But that $100,000 can be spread across the active participants in the ranch operation. So mom and dad, son and daughter, if they're actively participating, may be in line to each receive that $100,000 disaster payment. This is all conjecture and speculation because we don't even have a farm bill yet, but this is the way that it's worked in the past. And so if I've got an operator who came to me and said, you know what, Pat, I'm not worried about this FSA documents. Let's make a decision to go with the LLC. I'm willing to run the risk of being considered a single operator, even though I've got husband, wife, son, and daughter in the operation. I'll forego that payment limitation analysis. Well, I want to make sure that's documented in my file. I want to make sure that I've had that discussion with that client up front, that it's a confirming letter went out to that client at the time that we went into that entity organization to say, this confirms we discussed this risk. And you chose to go this route because you had other non-FSA payment objectives that informed your decision to go this route. So it's about documenting the file so you don't have to sit across the table with an angry rancher who said, now why in the world did you navigate me into this? And then you can show them the confirming letter that said we had other things that trumped those considerations, therefore this is what we did. So we want to be careful about making sure we document our file in that way. Another broad generalization, golden rule that we need to analyze is the Family Farm Corporation Act. And I find that a lot of advisors, legal and non-legal, overlook that we have a Family Farm Corporation Act in state law, codified in Chapter 47-9A. That's about the only statutory citation you'll get out of me today. But we need to be mindful that it's there, and it forbids, and it's detailed in my outline, it forbids corporate ownership of ag land. Whether or not it's used for ag purposes doesn't matter. The standard is if it's capable of being used for ag purposes, it's ag land, and you've got to comply with the Family Farm Corporation Act. And only qualified family farm corporations can own ag land in South Dakota. So we need to pay attention to whether or not our family is going to qualify as a qualified family farm corporation. Now, you just heard me say that don't own land in a corporation, and we won't. We don't. But note also that the provisions of 47-9A have been extended to include limited liability companies, LLCs, and advisors forget that. And we see time and time again where LLCs are formed to own ag land used for hunting operations. So the two doctors from Pierre buy a piece of ag ground in an LLC. They cannot possibly qualify as a family farm corporation, but yet they do it because it's cool to own ag land in an LLC. And I want that asset protection on that ag land against my buddy shooting another buddy when we're out hunting. But who's given them the opinion that you can own ag land in an LLC and not consider whether or not they qualify as a family farm corporation? And who's going to tell them that if the buddy does get injured, if they do rely on the fact that they've got a legally valid existing entity in South Dakota, that in fact it's not because you violate the provisions of 47-9A. So again, we need to document our file about whether or not that analysis has been brought to the table to discuss with our clients who clearly aren't ag families, who clearly don't qualify as qualified family farm corporations, but yet they're owning land inside of an LLC. How does that work? What does your file say about that? Now the solution is use an LP, use an LLP, use a triple LP to own that land, use a trust to own that land. All of those entity choices are not subject to 47-9A. 47-9A applies only to corporations and LLCs. So we need to be mindful of those rules. Another analysis that we have with our client is whether or not we have debt-encumbered land. Do we have land that's encumbered by debt? If we do, we have a tax risk. We need to engage our CPA. We need to know the extent of that tax risk and what we can do to navigate around it. The bottom line analysis is, does the cost basis, strike that, does the debt against the land exceed the cost basis the client has in the land? If it does, we've got a problem. If it doesn't, document it, get the CPA to sign off on it, and go on about your way. Discounting principles is another thing that we have a significant discussion with our clients about. And the discounting principles relate to, do we need to discount the value of the real estate or the assets being held by this entity to achieve our business succession planning purposes? And listening to my good friend Terry Prendergast, not for a tax reason, but corollary to that, to achieve our tax planning objectives in order to get those interests to the next generation at the least tax cost and in a way that fulfills our business succession objectives. In other words, we want to give our farm heirs the opportunity to buy those units, to buy those interests that own the ag assets at a discounted value. Are those principles important to this family? And if they are, then we go through the discount analysis, the discount discussion. And again, my outline talks about that in general terms, in a shirt-sleeve way, in a shirt-sleeve fashion, that gives you discussion points to visit with the client about whether or not discounts are relevant to this family. And one of the driving forces, in addition to discounting the value for intra-family transactions, is do we need to discount the value for federal estate planning purposes, for gift tax purposes, for transfer tax purposes in general? And it's not the sole reason we do these things, but it's a byproduct of getting into these entities and including terms and conditions in the organizational documents for these entities to set up that argument, to set up that analysis that will allow the opinion to be given that the business interests, as they transfer between generations, can be reasonably, fairly, and enforceably discounted as a result of how we've set our documents up. So we want to have that discussion and ascertain whether or not we have the need for discounts in this family. And then we need to watch our documents to make sure we don't backslide on those discount theories that we're trying to achieve. Because what you put in your documents will have the direct impact of whether or not you can take a discount and to what extent. So we've got to have everything coordinated and identify those provisions that could backslide on our discounting principles. We also talk to our clients about the concept of treating farm heirs and non-farm heirs fair versus equal. And you'll see as we go through some of these examples of the different types of entities that we select, that you can use your entity choice as a mechanism to fulfill the fair versus equal type objectives that our clients have. You know, the ability to segregate or bifurcate or define different classes of members in a way that creates purely passive economic members who have no say in the management of the company, and create a management class that consists of the farm heirs, the on-farm heirs being in the management class, being the boss of the operation. Mom and dad can achieve the objective of passing value down to the next generation and including the non-farm heir in that transfer, as long as that non-farm heir is purely a passive member, is one that just participates in economic benefit associated with that entity. And they have nothing to say with regard to the day-to-day management of the operation, because that management class is reserved to the on-farm heir who then operates that ranch operation or farm operation. So we'll have those discussions with our clients as well. We talk about asset protection and what entity form gives us maximum asset protection. South Dakota enjoys the reputation as being the #1 state in the nation for asset protection legislation. And we have achieved that status as a result of the changes that we've made to both our LLC statutes and our limited partnership / limited liability, limited partnership statutes. And the crux of it is that South Dakota says that judgment creditors have the sole and exclusive remedy of a charging order against an interest in an LLC or a limited partnership unit. And we've strengthened that language. We've tweaked it as the years have gone by to close off different attacks on that language. And we've strengthened South Dakota's position as the #1 asset protection jurisdiction in the nation. Our LLC and LP statutes are reflective of the concept of respecting the law of the contract. Terry eloquently said it in his comments about captive insurance companies. We respect the law of the contract. The agreements that the parties entered into that are governed by the terms of that operating agreement or that partnership agreement, we're going to respect that. And if we set those agreements up to put a barrier between those units, that interest, and creditors, predators, in-laws, and outlaws, our state laws will help enforce that. As long as it's not void against public policy, as long as it's not unreasonable, we're going to respect that. And that's important to know because you can draft your documents to protect those units and prevent those units from going where you don't want them to go as a family. So my preference for maximum asset protection choices relates to either an LLC or a triple LP. And on the triple LP, that's just that's a limited partnership on steroids. It's a limited partnership that we have registered with the Secretary of State's office to be a limited liability, limited partnership. And as a simple act of registering that triple LP for that label, for that status, we achieve giving limited liability protection to our general partner. So we distinguish a triple LP from a straight-up LP, and what you get with a straight-up LP is that the general partner always has unlimited liability exposure for the debts and liabilities of the limited partnership. And then that creates another need to layer in another general partner entity to limit that liability, because mom and dad don't want to incur that risk. Well, with the advent of triple LPs, the simple act of registering your limited partnership as a triple LP, we achieve limited liability protection for that general partner. So if asset protection planning is an objective and you have an LP, I can't think of a reason why you wouldn't want to register it as a triple LP to gain that extra measure of protection. Well, now we move into applying these general rules to our ag operation. And we talk about compartmentalizing key assets and segregating liabilities. And this chart's just a jumble of figures and words and different categories that you can carve up your ag operation into. And note the risks that your ag operation has against it. And for each of these different buckets, if you will, for each of these different figures, we can create an entity to help compartmentalize that asset and protect that asset against liabilities from another part of the operation and segregate those liabilities associated with that entity, with that asset, and confine that liability to that entity. So we're putting up barriers, we're putting up borders, we're putting up fences, corrals around our assets to protect them from liabilities that are coming from outside. And if there's a liability that arises inside of that entity, we confine it to that entity and it doesn't poison or put at risk the other assets that we have outside. So you can see, we've got the land, we've got the hunting, we've got the operating assets, the livestock and equipment, we've got mineral rights and other type interests, trucking operations. We want to protect against the kids. We want to protect the home and the personal assets. We can get crazy here. We can have a lot of fun. But the thing that you've got to do with your clients is you've got to have a discussion with them about the trade-offs between complexity versus peace of mind. Now, where do you land on that scale of complexity versus peace of mind in how we're going to structure this jumble of risks and liabilities and key assets. So you have to get a feel from your client about the level of sophistication that they want to engage in, the level of complexity, record keeping, paperwork, all the things that come about as a result of forming multiple entities. Well, the one that I focus on with clients, and the one that seems to resonate the most with our A clients, is the concept of protecting the golden goose. Protecting the key asset that represents the primary asset of that ag operation, and it's the land. It's the land. So let's visit about the concept of forming a land company to own that dirt, to own that real estate. And this is an end representation of what I'll do on the grease board with a family to talk about the different steps associated with getting to the land company concept. And you'll see in the materials the GPNA memo on land companies. And so I tell the client, now just focus on what I say, don't worry about taking notes. Just follow along in the discussion. And everything I'm going to say is contained in that land company memo that you're going to take with you. That you're going to sit around the dining room table with the kids and talk about. So let's just talk about the process right now. And it starts with a discussion of mom and dad, who has 5,000 deeded acres. And we exclude from that the home and the base acres, if they have a grazing permit. And we don't want to put homes in these entities. We'll talk about that in a little bit. But mom and dad have 5,000 deeded acres, and they want to protect that land for the next generation. They have principles of fair versus equal that they want to achieve. They want to avoid fractionalizing the ownership of that land as it passes from one generation to the next. They want to guard that land against the threats that are represented by the assaults on the horizon, predators, in-laws, and outlaws. And so what we'll talk about with them is the formation of a land company, a limited liability company, and I prefer to get all the bells and whistles that I want to achieve with this company to use a manager-managed land company. Manager-managed LLC. Now, if I have concerns about the Family Farm Act, I'll go the limited partnership route. And the management class is represented by the general partners. But those that are in the management class are the boss. They are the chief in charge. So it's mom and dad to start out with, and maybe the on-farm heir when mom and dad are done being the boss. But mom and dad like to hear that, yeah, I can structure the ownership of my land in a way that will protect it, avoid fractionalization, but I'm still the boss. They like to hear that. And we can structure that with a manager-managed LLC or a limited partnership with them as the general partners. And so we do a quick claim deed, kick all the land into the land company, and what mom and dad get back are economic units. And these units are the key. They're the economic units associated with their equity ownership in the entity. And this is like a share of stock. But we call them units, and I base it off of 100%, so you get a percentage of the units back in relation to your capital contribution to the company. But those represent the passive economic units that you can then transfer down to the kids, either by gift or by inheritance, to a combination of on-farm heirs and non-farm heirs. And those non-farm heirs that hold those units are passive. They don't have a say. Now your agreement's going to, have some provisions in there that may require their consent, may require their participation in the decision, but you get to decide that with your client. You get to define what those are. And we can truly structure a situation where they are passive and that the on-farm heirs, through the combination of the units that they own and putting them in the position of managers, will be in control of that land company. So that's a very important feature of how we set that land company up. But we've got to honor the formality of what we're doing here. And remember I said if we have FSA concern, program payment limitation concerns, we want to kick the operating assets out into a separate entity or keep them in mom and dad's individual name or in the kids' individual name. We don't want the operating assets in with the land. We don't want to put the land at risk for what might happen with regard to the operation of the livestock and the equipment. So we keep that out and we put a lease in place. And this lease is a key component to this structure. And the lease ought to be a fair market value lease to guard against alter ego theories, piercing theories, and you better honor the formality of having that lease in place. But the way it works is that lease gives the operating entity the right to use the land. They'll pay fair market value rent back, but that rent comes right back out to the members in proportion to their ownership interest. So it's almost as if you're taking it from your left pocket and putting it into your right pocket. But you've got to honor the formality of taking it through this in order to get it there, to keep the IRS satisfied, to keep the judgment creditor satisfied, to keep the predators, in-laws, and outlaws at bay. You can do the same thing with the hunting entity. We want to keep that hunting entity out. That hunting activity ought to be segregated in its own compartment.